Hello everyone, welcome to Let's Crack UPSC CSE English. About me, I am Sandeep Bhushan Thummala. I have 8 years of teaching experience for civil services. I teach international relations, internal security and in-depth analysis of editorials and articles. And this video or the session is in regards to how to crack prelims and also mains 2020. And prior to that, you have a notification in regards to Let's Crack UPSC CSE, which is India's largest learning platform, and it's the notification is in regards to the subscription. And once you get subscribed, you will have unlimited live and recorded courses from the India's best educators. And apart from that, you have the other privileges like daily live classes, live testing quizzes, structured courses, and also unlimited access. And these are all the top educators at Unacademy, wherein you can see it on your screen. And apart from this, these are the one who are the top educators at Unacademy. And in regards to Let's Crack UPSC CSE English, you have the following courses of all these, which you can see, like economy, geography, science and technology, current affairs, and all other what you can also have a glance at it on your screen. And apart from that, you have the again for Let's Crack UPSC CS English, you have essay writing courses, Indian society, social issues, and also interview preparation and all others what you can see it on the screen. And in regards to the subscription, you have 12-month subscription and 24-month subscription. So it's always better to go ahead with this 24-month subscription for Let's Crack UPSC CSE English, and you can use my code, that is Sandeep Bhushan Thummala SBT10, and once you use my code SBT10, you will get 10% discount on the original price, which is 48,300, and the discounted amount will be 43,200. So it's always better to go ahead with subscribing 24 months, because you are effectively paying for 13 months only the amount, because you will be paying 12 months, that is 40,000, and then for 1 month, that is 8,000. So overall 48,000 is for 24 months. So you will be paying effectively for 34 months, but you will get a subscription of entirely 24 months. So it's always recommended that while you are going ahead with the serious preparation for UPSC, then it's always recommended that you go ahead with subscribing for 2 years or 24 months, and which will be very useful for you. And if you haven't subscribed for Let's Crack UPSC English, then go ahead with the subscription 24 months by using my code SBT10, that is Sandeep Bhushan Thummala 10. And now we'll get into the topic, that is in-depth analysis of editorials and articles of the Hindu newspaper, which will be very useful for the prelims and also for the mains examination. As I keep on repeatedly saying that we need to, you as a civil servant aspirant, you need to identify, emphasize the keywords and the key phrases. Keywords and the key phrases from the editorials, articles, and also from the contemporary issues. So what is important is identifying the keywords and the key phrases from the editorials and articles, not only editorials and articles, but also from the other news items. You need to be in a position to go ahead. And this my session will be in regards to the in-depth analysis. When I'm talking about the in-depth, it is thorough and better and comprehensive So this is what my focus is in regards to thorough, better, and then comprehensive understanding about the editorials, articles, or else any news item which I take up. So before I get into the topic, I would say hi to Sushant. Good morning, Sushant. And now we'll look at today's editorial. And then have taken the photograph or the image of the Supreme Court of India. Can anyone guess what is the discussion or the class would be in regards to? Sushant, if you have any idea why I have taken the image of Supreme Court of India? Because it is pertaining to today's editorial itself. We will discuss about today's editorial. Okay, fine. I will get into the topic. Protection of healthcare. Okay, protection of healthcare. I mean, Supreme Court, you can talk anything also. If it is Supreme Court, then we can say anything. But here, in regards to Supreme Court, we would be talking, or else we would be discussing in today's class, today's session, in regards to the editorial which has the heading as no 100% quota protection for healthcare workers. Okay, fine. So today's uh, editorial is in regards to no 100% quota. So there is an editorial which is today's editorial which talks about the quota, and wherein the Supreme Court has given a verdict saying that there is no 100% quota, and this will be very important for your prelims as well as mains point of view also. And everyone who have joined, again I would say a very big hi to everyone. And today we are talking about the first, today's editorial. Pratham, can you explain the 2000 judgment bench in this editorial? Definitely, Pratham. I think you have gone through the editorial, but definitely I will, Pratham. Don't worry about. I will definitely make sure that you will be benefited by my lecture or by my class. Definitely. And the Supreme Court has given a verdict, and this is verdict is in regards to no 100% quota, which talks about, what do you say, a particular state which has given a 100%, quota, or in regards to the having more of reservation. So it was against the AP government. It was against the AP government. The verdict was against the AP government, wherein AP government has said that they will go ahead with the reservation in the tribal areas. So the Supreme Court has given a verdict that there will be no 100% quota, which was actually been made. I mean, the order has actually come up by the AP government, wherein they wanted to go ahead with the hiring of the teachers in the school, which would be the tribal areas, wherein it would be 100% from the particular tribal community itself. So what the AP government has taken up, the Supreme Court has ruled out. It has ruled out that the 100% quota is not possible, and we will look into the entire, what do you say, how many it is in regards to, we will focus in regards to the fifth schedule in regards to this quota. We will look at, extremely sorry, we will look at article 371D, fine, and then we will also look at whether it is possible that we can go ahead with how much quota in regards to the reservation. What is the reservation cap? Reservation cap. So fifth schedule 371, and then in regards to, what is a reservation cap, also what it is mentioned and how much it has to go ahead, we will look at it. So now I'll get to the topic, or else we will also look at whether there is any presidential order in regards to the fourth one. Also we'll look at whether there is any presidential order. Okay, that will definitely come under the fifth schedule again, whether there is any particular district or mandal or taluk which has various reservations in regards to the teachers or in regards to any other government recruitment process. So we will look at all those, and as Pratham was talking about, also I will also look at what has happened in the order, the order which has given up by the erstwhile or else United AP Andhra Pradesh in the year 2000. And then also we will look at not only 2000 but also here, I'll just give me 1 minute time. As I said, we'll also look at this article 371D also, and and also in regards to what has happened in 1986 also, for the benefit of Chavan, and also everyone, we will look at what has happened in 2000 and also in the year 1986, and then 2000 in regards to the erstwhile. The governor has spoken about the reservations in regards to the scheduled areas. Reservation in regards to the scheduled areas. This is very important. Scheduled areas. So we will look into the various keywords which will be very useful for the prelims and the mains point of view. So now we will get into the topic, that is no 100% quota. So the Supreme Court has quashed what it has quashed, the order of the Andhra Pradesh, erstwhile Andhra Pradesh, that is erstwhile in the sense United Andhra Pradesh. Then United Andhra Pradesh. Fine. So Supreme Court has quashed the January 2000 order. This is very important for the prelims point of view, because many of you will try to get into the topic wherein you will understand if the Supreme Court has quashed the Andhra Pradesh 100 or as quota in regards to the teachers, in regards to the schools, but it is in regards to the January 2000 order of the erstwhile Andhra Pradesh, wherein in that 2000 order, January 2000 order, it has provided 100% reservation for the scheduled tribe candidates. And these scheduled tribe candidates are the one who were actually, what you say, wanting to be or to get into the teaching position, or wherein they were applying for the teachers in the school, that is especially the schools which are in the scheduled areas. What are the scheduled areas? That is in the fifth schedule, we will look at it. So it is in regards to the scheduled areas. And then what the Supreme Court has said is, it has quashed saying that the whatever the AP government, erstwhile AP government, has given in regards to an order that was in the year January 2000 is not, what you say, actually right, or it was saying it was arbitrary and not permissible under constitution. So the Supreme Court has said that the January 2000 order is, I mean, what was order? It was in regards to the providing 100% reservation, 100% reservation for scheduled tribe candidates. Please do understand, this was for the 100% providing 100% reservation for the scheduled tribe candidates who were applying for the post of teachers, in the schools again in the scheduled areas. So when we are talking about scheduled areas, again in the tribal area, please to understand this is very important for analytical prelims and also mains point of view. So the Supreme Court now, it has quashed the January 2000 order, of which the United AP has come up with the 100% reservation for the ST students, wherein those ST candidates were actually who would apply for the teachers position in the schools which are in the scheduled areas, that is in the tribal areas. So that means what the Supreme Court has said is, giving 100% is arbitrary, which is not correct, and it is not permissible. It is not, what is taken into consideration under the constitution. So what is important is, here the focus we will do is, like, as per the constitution, why is it not 100% giving, 100% reservation for the scheduled tribes in a scheduled areas, wherein they would apply for the teachers positions in the schools which are again in the scheduled areas. This is very important. In the scheduled areas, why 100% is not permissible? That is what the Supreme Court says. And then it says that, quoting the constitution, as per the constitution, there is no provision of saying 100% reservation. It could be ST, I mean scheduled tribes candidates in the scheduled areas also, there is no 100% reservation. And the bench also has noted that a similar order, so definitely there was an order, see, Chauhan, there was an order again which was not only in the year 2000, prior to 2000 also there was an order again which was issued. So we are just, I mean the government has quashed it, but prior to 2000 the United AP, United Andhra Pradesh has gone ahead with the giving an order, the similar kind of order, that in the 1986, same way giving the 100% reservation for the scheduled tribe candidates in the schools wherein they were applying for the teachers post. So this was quashed. Again, the same what the Supreme Court has done it in 2020 was also being quashed in the year 1986. Please do understand, 1986. So even though it was quashed in the year 1986, again the United AP has come up with the order in January 2000. So for the first time, the order was provided by the United AP in the year 1986 by making sure that the scheduled tribe candidates would be given 100% reservation for the post they apply for the teachers in the schools wherein the schools are in the scheduled areas. First 1986, but it was quashed, and then it was quashed by whom? The State Administrative Tribunal. State Administrative Tribunal by the SAT, not by the court. Please do understand here. Here in 1986, it was quashed, that 100% giving reservation to the ST tribes was quashed by the State Administrative Tribunal. But later on again they have gone to, or they have approached the court. So that is the apex court. Against the bench said against the quashing of the order. So they preferred that the apex court, but it was dismissed and withdrawn in the year 1999. So in the 1986, when it was quashed by the State Administrative Tribunal, when they wanted to prefer, or they wanted to appeal the same kind of order which was passed in 1986 to appeal before the apex court, that is High Court, but it was dismissed and the government has withdrawn in the year 1988. So the government has withdrawn in the year 1988. So what is important for us is the chronological order: 1986, 1988, sorry, 1999. I'm extremely sorry, 1998. Just a minute. So for the benefit of the the one who would be preparing for the state services also I'm saying state services also, you will be benefited, because you need to look at this, the years. So first is 1986, it was quashed by SAT, and then they have approached 1988, but again it was dismissed by the apex court, dismissed, and then government has also withdrawn it. Fine. Again in the year 2000, the government has come up with an order, government order. Fine. Again, now if you look at in 2020, the Supreme Court has quashed it, has squashed. So this is what the chronology is for Pratham. For the benefit of you, I am explaining Pratham Chavan. So it is not just looking at 2000, but also looking at 1986, 1999, again 2000, and what has happened in 2020. So this is a chronology. It is good to all of you to understand, because it could be asked even in the prelims also. So we will look at little bit. So 1999, right? 1998. 1998. And then the governor then of the United Andhra Pradesh. So we are looking into the little bit of what is a background. We are looking into the background. So when we have taken into consideration of 1986, 1998, 2000 and 2020, we will look at what actually the governor has come up with, because the governor has come up with the order. It is the governor and then the state Andhra Pradesh together have gone ahead with the order. So the governor of then has said that, or he has cited about the Schedule 5 of the Constitution. So what that the Schedule 5 of the Constitution talks about, it provides the administration of scheduled areas in the states. So even the other scheduled areas which are in the different part of India is Assam, Meghalaya, Tripura and Mizoram. So this is again important for prelims point of view in regards to the scheduled areas. So who has the authority or the power to administer the scheduled areas? So it is as per the Schedule 5 of the Constitution, it is the state administration, or to be more precise, governor, because at the center it is the president. When he is talking about the scheduled areas, it is the president who defines the scheduled areas in consultation with the governor, of the respective state. So rather than state administration, it is the governor who actually looks into it, whether the administration of the scheduled areas in any particular state, it is up to the governor. And then again governor will have a consultation with the, or else president will have a consultation with the governor under the fifth schedule, under the Schedule 5 of the Constitution, and then make sure that how the administration of the scheduled areas has to go ahead. So we are looking at the concept. Please to understand the background, and the concept is very important. So here what we are going ahead is not only in regards to the Supreme Court, we are also getting into the point of what the governor's role is, and again the president's role is. Fine. So the governor then has gone ahead with saying, or he has cited, he has mentioned that as per the Schedule 5 of the Constitution, it is the who has to administer the scheduled areas in a state will be decided by the governor, and that again in further the president, as per the fifth schedule, will have the conversation or consultation with the, rather conversation, I would use the word consultation with the governor, and then later on they will define the scheduled areas. and once the scheduled areas are defined, then about administration the governor will come into action. Please do understand, the defining of it is by the president in consultation with the governor, and then in regards to the administration, it is the governor of the particular state will go ahead with taking the administration. So thereby, then in 1986 and also in the year 2000, the governor, I mean, why the assembly, or why the state assembly has come up with the order? Because the governor feels that as per the schedule 5 of the constitution of India, the administering of the scheduled areas are the duties or which have been provided or can be administered by the governor of that particular state. So the now we have also brought in governor. Fine. So now we'll again go back to okay. Pratham says okay. Good morning to Ram Kumar. Also very good morning. Hi to you, Ram Kumar. And in regards to, is the advice of governor binding? No. That is what, again the advice of governor, when that, if you look at the way the Supreme Court has quashed. So Supreme Court has quashed, saying that this scheduled tribe areas reservation is, or saying it was arbitrary, I mean it was single and it is not permissible. Why it is not permissible? Why it is an arbitrary? We'll look at it. So it is not binding. So anything, any action. Now if you are looking at the, now the point is in regards to the reservation. Fine, reservation, especially in regards to the, I mean this Supreme Court verdicts in regards to this scheduled tribes. Fine. So here when we are talking about reservation, again, who is the one who can actually, what you say, look into whether this, that amount of, or the quota of reservation is actually necessary or it is as per the Constitution of India. Who will look into it? It is the Supreme Court of India. So that is why it is not binding. Pratham, I think you are getting it. That is why it is not binding. So if you look at now, I mean when I go ahead with various Supreme Court referring to various cases, so we will not just look at what you say 2020 Supreme Court verdicts on the 100% reservation provided by Andhra Pradesh government, it has quashed. No, we will look at the previous cases also, on what basis the Supreme Court has quashed. Now you will understand better, Pratham. The Supreme Court has considered 10% reservation as anathema. Anathema means it's a curse. So Supreme Court says very clearly that 100% reservation is not correct. 100% reservation, even it could be what you say in regards to scheduled tribes in scheduled areas, or it could be in regards to scheduled tribes and then again scheduled caste, or else other backward classes. In regards to any kind of reservation, the Supreme Court considers that 100% reservation is not correct. It is a curse. In fact, what it is saying is anathema. Anathema in the sense, it says that it is a curse. Why is it a curse? It is a curse to the constitutional scheme of equality. So it says that it is a curse to what? To the equality, because the Constitution of India provides equality. So when we are talking about equality, definitely reservation is part of what is providing equality. But when the reservation is 100%, again it is against the reservation, against the equality. Please do understand the concept here. Reservation has come into existence to provide, or to what you say, create equality, to, I mean to some extent and for some time itself. Fine. And then later on, again when the reservation is taken up in 100% itself, again it is against the equality. Fine. So that is what the Supreme Court has said now, saying that it is giving 100% reservation is an anathema. Anathema in the sense, it's a curse to the concept of equality. For the concept of equality, no doubt, when we are talking about equality, actually equality has come into existence because taking into consideration the deprived section. Please do understand, the equality has come into existence, or else the reservation has come into existence, keeping into mind the deprived sections or depressed classes or depressed sections. So keeping in that mind, the equality has come, and then reservation has come into the forefront in our Indian Constitution. But 100% reservation is not accepted, what the Supreme Court says, and it is a curse to the concept of equality itself. Fine. I think you are understanding, Pratham. Are you getting the point? And not only that, The bench also not just talking about whether the 100% reservation is good or bad, or it's a curse to the concept called equality. So when we are using the word, when we have looked at the word curse, anathema, please look into that. I mean, please do try to emphasize on the keyword. Anathema is a keyword here. Fine. And then deprived section or equality is also a keyword. Please do. You know that all this, but while you are writing your mains, you have to mention that. Fine. Now the Supreme Court has not just taken into consideration of 100% reservation is a curse to equality. It's not only that, it has also considered the previous judgments. So it has gone back, it has referred. Now the Supreme Court now it has referred why 100% is not possible, why it is not correct, why it has quashed the Andhra Pradesh order of 100% is because of the referring it back to the 1992 Indira Shamni versus Union of India case or judgment 1992, and this, what do you say, respectable person is Indira Shamni. So 1992, this respected person is Indira Shamni. So it was Indira Shamni versus Union of India. In that case, there was a judgment made, and that Indira Shamni judgment, you can, I mean, it is also called as Mandal Commission verdict. So this Mandal Commission was during the VP Singh government. Please do understand all this. It was during the VP Singh government, and this Mandal Commission was the one who was into looking into that is the name person called as BP Mandal. BP Mandal. See, please do understand from prelims point of view, I am trying to focus from each and every point. When I was saying comprehensive understanding, comprehensive explanation I would give, definitely this is what the comprehensive or thorough better explanation is that. So it is Mandal Commission verdict. It was in the year 1991, 1992 itself, that time. So Indira Shamni case judgment, which was versus Union Government of India, and it is also called as Mandal Commission. And during that time, the Prime Minister was VP Singh. Fine. And then the one who was Mandal Commission, the one who was heading that commission was BP Mandal. Fine. And then there in that the apex court has emphasized in the 1992 Indira Shamni judgment case, the apex court or the Supreme Court has emphasized that what it has emphasized, that the founding fathers have gone ahead with the reservation of all the seats, that which will not exceed 50%, and the quota shall be the rule. And what is a quota? That is what is important, what we are talking about. Quota is how much? Quota is 50% for the reservation, and it should not cross that 50% reservation. So what, according to the Indira Shamni case, in the Mandal Commission verdict, it was very clearly stated by the apex court that as per the founding fathers, the reservation of all seats and the quota should be the rule, that is not exceeding 50%. Okay, you can say that. Again, I would give a point here. Tamil Nadu goes ahead with greater than 50%. Fine. Why reason? Please let me know. Tamil Nadu is only one state which goes ahead with 50%. And this reservation, it is placed in which schedule? 16%, yes, which is beyond 50% sailing. Why is this so? That is what I am asking, Janvi. I am asking the others. I am asking the others because it is this cap quota is placed in one of the schedule. How many schedules you have totally? 8 plus 4. Am I right? 12. 8 plus 4, 12 schedules. Or I'll write here 8 plus 4. When I'm saying 8 plus 4, initially 8 and then later on, that is 12. So 12 schedules. So which this quota of Tamil Nadu? Yes, absolutely. 9th schedule. So once it is, what do you say, you place anything in the 9th schedule which will be permanent. Fine. And that is why Tamil Nadu is going ahead with that 69% which has crossed the quota, and the quota is 50%. So now I think you are understanding it better of the way we are going ahead with the discussion, not just AP, again comparing it with the 1992 Indra Shani case, wherein it was very clearly or emphasized that the emphasis was made in the judgment that they would be going against, they would be going with and not against the founding fathers, and not against the founding fathers. So what the founding fathers have said, that the reservation or the quota should be not exceeding, or it will be only 50 percentage. And the other case, what we are talking about, the Indra Shani judgment case, also 1992, it was also noted that there is an extreme caution which has to be exercised and special case which may be made for exceeding 50 percentage of reservation limit. And what Janavi were talking about, that Tamil Nadu is the correct one. The bench noted that as per the 1992 verdict, extreme caution has to be exercised. Extreme caution has to be exercised, that 50% quota should not be exceeding. That 50% quota should not be exceeding, and then a special case has to be made out for exceeding 50% reservation limit. Please do understand, there are 2 points in this one statement. Please do understand. One is that extreme caution has to be exercised, that the 50% will not be, 15% quota should not be exceeding. But there is also another statement. Statement 1 is this, extreme caution to be exercised, and the statement 2, in this itself you can consider as special case has to be made out. Special case has to be made out for exceeding 50% reservation limit. So now when the Supreme Court has taken into consideration of Indra Shani judgment of 1992, wherein it also emphasized that a special case has to be made exceeding, whenever there is what you say, greater than 50 percentage of reservation, then a special case has to be made. So when there is a, what is a point mentioned in the 1992 verdict, yes, the special case defined, that is what when there is a, that is what I'm saying, when there is a what do you say, keyword or key phrase which is mentioned, the special case which is mentioned in the 92, then why this, if 100% exceeding in the scheduled areas is unconstitutional. See, I'm not having any knowledge as per what the Supreme Court of India has or the judiciary has, but just for our, what you say, discussion, just for our discussion, in a in-depth analysis, that is what I always emphasize, in-depth analysis. So what is this in-depth analysis? Whether when there is a special case, so what, how does the, now here the point is, when it is special case, it is the Supreme Court which will define this special case. I think now Pratham is understanding it. We will look into both the sides. We'll look into both the sides. It is like when it is mentioned, why not it consider 100% as constitutional, and why Supreme Court is saying 100% reservation in scheduled areas for scheduled tribes people applying for the teachers post in school is unconstitutional, because these special case will be defined as per the situation time to time by the Supreme Court of India. So that is what the point is. And then the 5 judges bench, also headed by Arun Mishra, has made it very clear that 100% reservation would be unfair, unreasonable, and no mandates. And then it says that there is no law which mandates only tribal teachers have to teach in the scheduled areas, or teach in the schools of the scheduled areas. Now I think you are understanding it. The Supreme Court has the, what do you say, point to be taken into consideration when they will look at a case as a special case, right? And then this the bench headed by Justice Arun Mishra has made a point saying that this 100% is unfair, unreasonable, and there is no law which states that only tribal teachers can teach in the tribal areas. So when this point is made, definitely there is what you say unconstitutional, unreasonable, and not permissible, unfair, all this what you say used by the Supreme Court against 100% reservation, they feel it is deemed right. And then the bench found that the teachers post or else the recruitment in the teachers post in the notified areas under the fifth schedule of the constitution also adversely affected the interest of other candidates, that are who are the other candidates, that is the scheduled caste, other backward caste, and also SC communities of who are not native to those areas. So this person, I mean this gentleman, Justice is Justice Arun Mishra. Justice Arun Mishra. And what the bench has also said is not that when we are saying 100% reservation is not accepted, it is unfair and unreasonable. We are not just talking about what you say the reservation which are only for the ST or for the open category people. Not only for the open category people, but they have mentioned about that it would be the interest, I mean it would be affecting the interest of the scheduled caste, scheduled tribes, and other backward communities. So look at the way the Supreme Court has looked into various aspects when they were saying 100% reservation is unfair, and then it is unreasonable, and it is unpermissible levels, and it is no law wherein it is mentioned that only tribal teachers can teach scheduled areas. Here I would mention, okay, I will not get into that controversy again. There was one, I think in JNU, if I'm not wrong, recently, an ex faculty has come to teach in what do you say of JNU in one of the Y department. So which was not what do you say initially accepted by the various union or various people. They have said that it is not acceptable. Okay, I will not get into that. But what is important is the Supreme Court has said that because of this, even though if it is when the teachers that earmarking teachers post in areas notified under fifth schedule of the Constitution, it is mentioned in the Constitution, that is in the fifth schedule of the Constitution also, but it adversely affect the interest of the SCs, STs, and other backward communities. And then Pratham also says that can inaccessible areas considered as a special case. That is what I am saying. It all depends upon the Supreme Court how it constitute. I mean considers or constitutes the special case as at that particular time or situation. An inaccessible area considered as a special case, which is mentioned in the editorial. Okay, the editorial is a view of the editor. Tomorrow you can also be the editor, I can also be the editor, but what is important is how it is construed by the Supreme Court as per the situation. Because see, all the judgment, because we have seen if the judgments, if there are few judgments in the past, fine, the same again I mean the judgment related to the particular case, again now if you are talking about now, the case would be something else. I mean they would say against what has actually been expressed in the past. So it all depends upon the situation, the particular time, the situation, right? And then many a times it is also dynamic. The judgments are not always final. It would be dynamic depending upon the socio-economic conditions, dynamic situation of the country or the state. It keeps on varying. That is why many a times we feel like finding fault at the judiciary, but at that time, that situation, depending upon the socio culture. Okay, again, when we are talking about when the judiciary, we are talking about it should be practical, rational, impartial, not in regards to what is a cultural. But the judiciary also sometimes takes into consideration of the what is a culture, tradition, and then the judgment would be given. Not totally into that, but definitely it will be. So again, once the situation or else the kind of the technology or the social awareness, everything comes into action, then probably after 20-30 years down the line, the same judgment can be said that no, it is wrong, and then they can come up with the new judgment. And the bench also said that there was no such extraordinary circumstances. There was no such extraordinary circumstances in regards to there was no such extraordinary circumstances in regards to the 100% reservation in scheduled areas. So we are looking into various aspects how the bench has put forward that 100% reservation they have quashed. We are looking into the various reasons or how it has gone ahead with. Fine. And the bench also has emphasized that merit cannot be denied. This is again very important. The bench also emphasized saying that it is unfair and non permissible and all that. It is also saying that merit cannot be denied. So it is also considering not only the what do you say when it is mentioned in the fifth schedule in regards to the scheduled areas, it is not just saying it is adversely affecting the scheduled caste, scheduled tribes and the other backward communities, but it is also mentioning about the merit. Please to understand the way the Supreme Court has taken up the case or else the verdict, they have come up with a verdict looking into all the areas or from various angles or various perspective. This is very important. While you're writing an answer, you have to write your answer taking into consideration from various perspective, at least maximum. So here they have also emphasized on the merit cannot be denied providing reservation, and the order providing 100% reservation is arbitrary, illegal, impermissible and unconstitutional. So look at the word, the what is a various keywords the Supreme Court has taken into consideration only just by what you said using the word merit. So using the merit, it is reservation is arbitrary. I mean the 100% reservation is arbitrary, that is one-sided, and then illegal. It says illegal also, impermissible and unconstitutional. So merit is very important when it comes to what you said this judgment, right? And the bench also has asserted that action defies logic. So what the bench has said is the state government's action defies logic. So whatever the state government, that is the AP government, has taken the decision that the teachers would be or should be from the tribal areas or from the scheduled areas only, they will have to apply, and those people only will get the jobs as the teachers in that scheduled area schools. Fine. So what the bench asserted is the state government's action defies logic. So look at the way the Supreme Court has made the statement. The action of this AP government defies logic, it says, and the court concluded that reservation, 100% reservation which has been brought up by the AP government, it violates Article 14, Article 15 of 1 and Article 16. Again, this is very important for the prelims point of view. So you may not focus that the 100% reservation taken by the AP government or the order by the AP government was quashed by the Supreme Court under which articles it is against the order, the order of AP government in regards to providing 100% reservation for these scheduled tribes in scheduled areas for applying for the post of teachers in the schools of scheduled areas is against or is violating or has violated which among the following articles? Article 1, 2, 3, or option 2. So it is Article 14, it is Article 15 of 1 and also Article 16. So what does Article 14 says? We all know it is equality before law, and in regards to Article 15 of 1, it is discrimination against citizens. So you are discriminating that 100% should be from that particular scheduled area. Why not from the other scheduled areas who are also again STs or scheduled tribes? Why not? Why not get them? Who, if they have the merit, why not get them here and then be part of the what is the schools or be as a school teacher in that particular scheduled area? Why not? Is a big question mark now, and that is what the Supreme Court has said that. The Supreme Court has said that 100% reservation violates the Article 14, Article 15 of 1 and Article 16, and these are very very important for prelims point of view. These are very very important for prelims point of view, because we, as I say, I take up in-depth analysis, not just what you say, saying that this is what has happened. No, we will look at why it has happened, how many areas the Supreme Court has taken into consideration while delivering the verdict, and then which articles, and then which were the in regards to which were the previous judgments the Supreme Court has also considered while delivering the verdict. So these are the various, what you say, angles or the issues we need to keep on focusing on. So Article 14, Article 15, Article 16, it says, the government says, sorry, the Supreme Court bench says that it is against, the action of the government is against Article 14, 15 and 16. Pratham, are you understanding? Yes, yes, yes. Prince Kumar. Okay, who is Prince Kumar? Hi to Prince Kumar also. And Kumar, I am discussing about the Supreme Court verdict which has quashed the AP 100% reservation. Fine. Okay, fine. Sushant, are you there? Janavi, are you there? Janavi, Sushant, Ram Kumar. Fine. And then the Supreme Court, citizen of India. Okay, fine, very good. And then while the bench or the Supreme Court, while dealing in regards to the quota, so what is importance quota, and the what the Janavi. Okay, fine, very good, Janavi. And then the, no, why I'm asking, why I'm what do you say, asking you all is because it is not just what you say we have just looked at, or else I just did not take in regards to what editorial was just talking about, because I did mention about the points which are not in the editorial. Please do understand, I have mentioned the points which are not in the editorial, taking into consideration that it will be useful for you all, for the civil servant aspirants. That is what my point is. My concern in regards to what you say, in-depth analysis, I always say, is because of that you need to have a comprehensive analysis. Because if a question is framed from the prelims or mains point of view on this, you should not lose even a single point out of it. And that is what my concern is. And my teaching or my area of competency in regards to teaching is always in regards to the in-depth analysis. And the dealing with the issue of quota, what the Supreme Court has said is, the top court said is, the rights of tribals who are not residents of the scheduled areas shall be adversely affected. Please do understand, shall be adversely affected if 100% quota reservation is provided in such areas. Now probably more of what you say explanation or understanding you would get, because it was talking about unfair, unconstitutional, illegal and all that. Not only that, and it was also talking about it is against the merit itself. Yes, all those are correct, but the ultimate point what the Supreme Court has spoken about is in regards to the quota system. So when we are talking about the quota system, definitely the Supreme Court has brought in one point or one phrase, that is rights of tribal. Please do understand this. Again, this is very very important for prelims and also for the mains point of view. Rights of tribal, quota system or quota, and again emphasizing on the rights of. So rights of tribal, what it says is, once you go ahead with going ahead with 100% of reservation, if it is provided, then it will affect adversely the rights of the tribals who are not resident of scheduled areas. Please do understand now. For example, this is a scheduled area, this is a scheduled area, this is a scheduled area. Say for example, the distance between both, I mean all of them, is somewhere around 20-30 kilometers, 20 to 30 kilometers. Please do understand, I'm just giving an hypothetical situation, 20 to 30 kilometers. Fine. So here you have scheduled tribes, here you have scheduled tribes, here also you have scheduled tribes. For example, we'll take this, what do you say, this scheduled area, that is Z scheduled area, wherein there is a recruitment for the teachers. in the school, fine. But here, probably because of for whatever reasons, the positions are still left out. I mean the appointment has not taken up completely. The appointments have not taken up completely, or else all the posts are not filled. Please do understand. So in that case, shall we not go ahead with what is an ST who can apply here in the scheduled area Z, or an what is a scheduled tribe from Y scheduled area can apply here? Definitely. So if you are talking about this scheduled area only, that 100% within only you have to what you say go ahead with the recruitment, and if that recruitment is not totally what you say filled, or there are various what you say posts which are vacant. For example, we'll take this concept. If there are various posts or couple of posts which are vacant, teachers posts which are vacant, for example, in this Z scheduled area, then why not the scheduled tribe of from the X scheduled area, and then the scheduled tribe a person of Y scheduled area, why not he or she apply here? If it is 100% here, then what the code says is it is adversely affecting the rights of the tribals who are not resident of this Z. Please do understand this Z scheduled areas. So that is what, look at the way the Supreme Court has looked at various aspects, and then it has given its judgment and it has questioned. No, I'm not saying see here, I'm not saying that it is good. I mean the Supreme Court is good, and then the order of the Andhra Pradesh or United Andhra Pradesh was wrong. No, I'm not talking about. I'm just trying to look at the various key phrases of the Supreme Court, how it has what you say looked at, emphasized, and then it has given its judgment. No doubt, again, when we are talking about fifth schedule, it is again that president and governor has the right to go ahead with the administering of the scheduled areas. That again I will talk about it. I mean, I will support that. Fine. Before I go, Prince says I think many of them misusing the reservation. Okay, fine. Okay. And Prince Kumar also says creamy layer concept should apply for SC STs. Okay, very good. Concept, yeah, concept also should be applying. Okay, that is what I'm saying in regards to the reservation. The one who will, when we were talking about the scheduled areas, it is actually in the fifth schedule. Fine, it is in this fifth schedule. Fine. And then again, when we are talking about fifth schedule, it is the president who will decide or define the scheduled areas in consultation with the governor, I said. Fine. And then the governor will look into the administration of the scheduled area. Fine. So when it is administration, definitely again in regards to the reservation of, or else the appointment of the teachers. Here again, when we are looking at appointment the teachers, it is definitely the 100% reservation what we are talking about. So again, if you look at reservation, again it is a Supreme Court which will decide whether there should be a creamy layer concept in the scheduled caste and scheduled tribes, wherein this creamy layer of the scheduled tribes and scheduled caste and scheduled tribes are the one who are actually what you say as a hurdle. Please do understand, as a hurdle for the real needy people of the SC and ST, wherein they should get the reservation, or they should actually what you say get the reservation. Fine. If that is the case, yes. What you say Kumar was talking about, that yes, definitely. If that is the case, then the Supreme Court will take the decision. The judiciary will take the decision. Whether, I think even now also you have that. I mean, the creamy layer in the SC STs, you have that. The government is definitely for it. And Prince has written fifth schedule administration of scheduled areas says provision of administration and control of scheduled areas and scheduled tribes. Absolutely, absolutely. And then now we'll get into the what do you say? The Andhra Pradesh found that there was chronic absenteeism. So why the AP government has gone ahead with the order? 2000 or else 1986. We will focus on 2000. Fine. What the government, this is the United, in 2000 is United. Fine. United AP. So they found that there is chronic, I mean very severe absenteeism among teachers. Please to understand this point. Then you will know why the order given by AP of 100% reservation is correct. But again, we cannot take it into consideration of only one point and say that 100% reservation should be made. It is ultimately what you say, the governor, and then the Supreme Court is the ultimate to judge. So they felt they have experienced that there were a lot of absenteeism among teachers who did not belong to the remote areas. That is, wherever we are talking now, we were talking about that Z scheduled area. Please do understand, I was talking about X, Y, Z. Fine. In this Z scheduled area, if suppose there is a what is a recruitment for the teachers, and then as we looked at the previous the hypothetical situation from Y, if the recruitment has taken, an ST has been recruited to teach in a school of Z scheduled area, nothing wrong about it. But what the AP government has said is there was a chronic absenteeism among teachers. So you have teachers from the Z scheduled area and also teachers from Y scheduled areas who are teaching in a school which is in Z scheduled area. Fine. So what the government says is that there was a chronic, very what is a severe absenteeism of teachers among teachers who did not belong to this Z, but they have been belonging to, or they had belonged to X and Y, other remote areas where school were located. So for that reason, the government has taken, that is the AP government has taken that the appointment or the recruitment of the teachers should be in regards to the scheduled areas, the schools, the teacher recruitment of the teachers should be within. So I think now you understood. It says because of the absenteeism they have gone ahead with that, and the bench noted, and for this what the AP government has said, and the counter is from the Supreme Court. What is the counter from the Supreme Court is Andhra Pradesh government could have come up with other incentives to ensure the attendance of the teacher rather than 100% reservation. Are you getting? I think everyone is understanding now. We have gone into the in-depth, started from what do you say, the Supreme Court has quashed Andhra Pradesh 2000 order, I said we started with, and now we are ending with that. Why? Because what AP government was making the point was because of the absenteeism, but what the Supreme Court bench has what do you say countered to the Andhra Pradesh government's reason of 100% reservation in scheduled area is that they said if the absenteeism is the only cause, then you should have gone ahead with what is a various other incentive methods. You should have come up to make sure that the attendance of the teachers increases. So they say that you have alternatives, not 100% reservation is appropriate. Please to understand my point. Probably the bench might have said that you have or you should have taken other alternative mechanism or methods into implementation to make sure that the absenteeism is reduced and the attendance is increased, but not by going ahead with the order that is 100%. Okay, Pratham Chavan says mainly to curb the monopoly of interest among the reserved classes. Okay, fine. Yes, fine. And this is what do you say, Andhra Pradesh Legislative Assembly, a new one. And then we will just look at what do you say, what the Constitution provision says. And then Dr. B.R. Ambedkar, the what do you say, the founding chairman of the Constituent Assembly, has debated in the Constituent Assembly that there should be equality because the Supreme Court has made a point. I'll just give me 1 minute time. I wanted to what do you say underline that word, what the court has said, verdict, Supreme Court has said. Because it was also, the Supreme Court also was talking about equality. It is against the equality, providing 100% reservation. Okay, fine. I'll just move ahead. So even the Dr. B.R. Ambedkar has also during the debate in the Constituent Assembly has emphasized on the equality clause. He has emphasized on the equality clause that in regards to reservation, normally it ought to be only for a minority of seats. Minority of seats, not 100% of seats. Please do understand. Now you are getting to the main points. I mean, we are getting into the in-depth in regards to the quota system, in regards to the scheduled areas, in regards to how, what do you say, equality means, the word equality means, how it is really important, and then how the Supreme Court has taken into consideration of various judgments, Indira Shani case, Mandal reservation, and then again emphasizing on the founding fathers what they spoke about the equality word, equality. So minority of seats, please do understand, here it is not minority majority. Here it talking about minority in the sense less of seats. I mean limited seats. Less in the sense minority is like limited. So reservation has to be for limited seats, not for 100% seats. That is what the concept. Dr. B.R. Ambedkar observed that during the debate in the Constituent Assembly on the equality clause, this is again very important keyword, that any reservation normally ought to be for a minority of seats. And this is one of the point why Supreme Court often urged, or it takes into, what you say, whenever it goes ahead with the judgment, that 50% cap is because of what Dr. B.R. Ambedkar has made it very clear during the debate of the constitution when he is talking about the equality clause. Please do understand, he has spoken about the reservation in regards to the reservation has to be maintained, or it should be only in regards to minority of seats, only when he was talking about equality clause. Equality clause, only in regards to that he was talking about. Fine. And then, but there should be some allowance for relaxation in special circumstances. So what Pradham was talking about, special cases, or else what here again the Supreme Court says a special circumstances is again decided by the Supreme Court of India from time to time. From time to time, this is very important. From time to time, this is very important. Chavan says mainly to, okay, fine. So I think you are understanding it. So definitely it will be, I mean, of the total reservation, albeit in the sense, although with some allowances, that means some kind of reservation for relaxation in special circumstances. This is again a keyword, special circumstances, special cases will be again decided from time to time by the Supreme Court of India. And under Article 371D, the President issues orders that a resident of district or zone cannot apply to another district or zone for appointment. Please do understand here. Cannot apply. So when we are talking about cannot apply, so what does it mean? So what the AP order is correct. Please do understand. Cannot apply. As per the Article 371D, the President issues order, or it has, as per the 371D, President has, you have the presidential order that a resident of a district or a zone, resident as per Article 371D, again this is very important for prelims point of view, district or a zone cannot apply to another district or zone for appointment. This is as per Article 370. Again that can be contradicted, or that can be overruled by various other articles. Fine. So as per Article 371D, it says that the resident of a district or particular zone cannot apply. So you have this, what do you say in regards to that, you have free zones. Please do understand, here I am making a point again which is not part of editorial itself. You have zones called as free zones. Free zones in the sense, for example I'll take, for example, any capital cities. and I would take just for example Hyderabad, fine. And then when it was United AP, you have a zones, then it was, what you say, 5 zones, or you also have 5 to 7 zones. So all the, what you say, students, or the one who are aspiring to apply in the Hyderabad can apply. This is also district, but as per article 371 you should not. But it's only the persons who are part, or who are, what do you say, the resident of Hyderabad district only should apply for the post. But when it is declared as a free zone, then anybody can apply. So you have for this again some counter. That is why I am saying, when you read it only in regards to article 371, then the president order which he is talking about, and resident of district of one district should not apply in the another district. It applies only in regards to that. But when it is again being amended, saying that, as I said, as a free zone, then again it is different. Thus 100% quota deprived residents of scheduled areas of any opportunity to apply for post is against, it is depriving the residents. So when we are talking about article 371, and then again in regards to what equality we were talking about, and then 50% cap, it will definitely deprive few of them who are really required in regards to the reservation. And then way forward, what is that? So what is important is that, see, now your point, Pratham, you were talking about, sir, what about special class, special case, or special circumstances? What, I was going ahead with these two words, case and circumstances. So what is important now is debate is important. It is a matter of debate whether the ceiling, that is quota, that what 100%, or whether it is how much percentage, how much, as innate sanctity, innate in the sense essential sanctity. But it is clear that whatever it is imperative that a cap be breached, a special case must be made for it. Please do understand now. Pratham, I think you are getting the point now. What it says is, a few suggestions. Whatever could be the decision, there has to be a debate. And in that debate, to make sure that to have a better, few of them, for the deprived, especially for the deprived classes, even though the quota or the cap what we are talking about, it can be breached. It can be, I'm saying, can be breached. That means whatever 50% it is, they can go against or above, and a special case must be made for it. That is what you were talking about. All that is the last point I have made it, Pratham. Mainly to curb the monopoly of the interest. Okay, yes, okay, fine. So what is that? You need a debate now. There is a necessity of the debate now, and that is very important at this time. Fine. And the debate should not divert attention. And what is extremely sorry, and what is also important is that we need to have a debate, but at the same time the debate should not divert the attention. What the attention? That the kind of continuing the reservation which is going ahead for the STs, which is part of the 5th schedule, should not be disturbed, should not be diverted. Because once you are talking about 100% is, or else it's unconstitutional, or you are talking about equality, or you are talking about special cases or special circumstances, yes, there has to be a debate, and then a special case must be made. But it should not, the debate should not divert the attention. The debate should not divert the attention. That is, what do you say, the need of the hour. The need of the hour is to make sure that definitely there has to be a debate. There has to be a mention about how far that 100% is really valid. And then we'll just look at very fast about in regards to what is about 5th schedule. So about 5th schedule, it is a constitutional provision which is, what you say, as per the article 244 of 1 of the constitution. The scheduled areas are defined by the president, as I said, and they are what you say mentioned in paragraph 6 of 1. Again, these are very important for prelims point of view, because the Supreme Court, the latest judgment is in regard to the scheduled areas. So there is a possibility that there could be a question framed on the scheduled areas, and as per this, on the scheduled areas, fifth schedule could be a probable question, and this is as per the article 244 of 1, wherein the scheduled areas would be defined by the president by an order, and then it would be as per the paragraph 6 of 1 of the fifth schedule. This is very, very important for prelims. And the fifth schedule under 244 1 of 1, it says that it can go ahead with the constitution provides provisions for administrating of the scheduled areas other than the Northeast India. So you have different from Northeast India. The fifth schedule, which is also 244 of 1, which talks about the scheduled areas or in regards to the constitution provisions of defining the area as a scheduled area, but it is not pertaining to or excluding the Northeast India, and the specification for scheduled areas, that which area has to be notified as a scheduled area, which area or which part of the state has to be notified as a scheduled area will be decided by the president, but in consultation with the governor of the state, as I mentioned in the initial itself. The importance is that the specification of the scheduled areas, for example, this you consider this as a scheduled area, so this area would be notified as a scheduled area, not notified area, notified as a scheduled area only by the presidential order or president, and then president will go ahead with the order, fine, and then president will have the consultation with the governor, and this point is very important again for prelims, fine. And this there is also one more, we were talking about paragraph 6 of 1 of 6 of 1, and there is another provision in paragraph 6 of 2 of fifth schedule of the Constitution of India, wherein it says that the president may, first is to define, and the next one in the paragraph 6 of 2, it talks about the increasing the area of any scheduled area, again there in consultation with the governor, and then after the consultation with the governor, a fresh orders would be again defined, that what is the entire area of the scheduled area in particular to the states. Please do understand, you have the paragraph 6 of 1, you have the paragraph 6 of 2. Paragraph 6 of 1, for the benefit of the viewers, others, I would talk about that. It talks about the defining of the scheduled areas, and 6 of 2, it talks about whether there is a possibility of increasing the area of any scheduled areas, fine. So fifth schedule, you have article 244 of 1 of Indian Constitution, and then paragraph 6 of 1, and then paragraph 6 of 2. 6 of 1, it defines the scheduled areas. 6 of 2, it alters or alters, better to use the word alter the scheduled area, and then again a new notification or a fresh order will be issued for the entire area of the scheduled area. And what are the criteria for declaring the scheduled areas? First is they will look at the majority of the tribal population, only then it will be declared as a scheduled area. So when we are talking about scheduled areas, it is in regards to the scheduled tribes or the tribal areas, fine. And then compactness and reasonable size of the area. So they will not just look at the population, they will look at the area also, and then they will also look at the administrative entity, such as whether they can go ahead with having a district, block and taluk. So when we are talking about area, they will look at whether there is a possibility of administrative viable, that they will have an entity like the district, block or taluk level, wherein administration will get into action. So it is the population, it is the area, and then it is in regards to administrative viability, and then they will look at the economic backwardness of the area. So first is the population, second is the area, and then the third one is whether they are viable administrative entity like districts, blocks and taluks, and the fourth one is they will look at the criteria for the declaring the scheduled area is in regards to whether it is economic backward, that area is economically backward compared to the neighboring areas. Please do understand, this point is very important, comparing to the neighboring areas. So this is what is very important in regards to the scheduled also. So we have looked at definitely various aspects which are really very important for you in regards to the prelims and also for the mains point of view, because this judgment will make sure that it will provide at least one or two questions in the prelims and also in the mains examination. It could be under the scheduled areas, tribal areas, or it could be in regards to the quota system, it could be in regards to the equality, it could be in regards to the fifth schedule, it could be in regards to the Article 371D, or it could be in regards to the Part 3 of the Constitution, or it could be in regards to the Article 244 of 1. So you have looked at, we have looked at various aspects that how it would be possible that the question could be framed from the factual, analytical, from the prelims and also mains point of view. And then I also, for the benefit of the viewers, also I made sure that the chronology 1986, again in regards to the 1998, 2000, 2020, the final judgment. As of now. So no, the article talks about, or else the editorial talks about no 100% quota as of now, as on today, depending upon the situation or the interpretation of the Supreme Court looking into the Indra Shani judgment or the Mandal Commission judgment. Fine. So I feel that I personally have taken enough of explanation in regards to making sure that you understand it better from the prelims point of view and also mains point of view. And then I hope it was a very good discussion, helpful for you, knowledgeable one for you. Okay, Pradham says that thank you, sir, for our informative discussion. Yes, definitely. As I keep on saying, Pradham and everyone, that I will never go ahead with an what do you say, a lecture or explanation which would be from only for my sake or from my end. No, I look into the aspect of the civil servant aspirant and then would wish to give the maximum benefit or maximum knowledge and then an in-depth analysis. Thank you, Pratham. Thank you, Janavi. And then please make sure that you like the video, subscribe the video, hit the bell button, and while you're watching the video, that is Let's Crack UPSC CSE English. And if you haven't subscribed for Let's Crack UPSC CSE English, please do subscribe for 24 months. 24 months by using my code SBT10, that is Sandeep Bhushan Thummala 10, wherein you will get 10% discount, and then you will be actually paying 13 months of amount while you are subscribing for 24 months. And if you haven't subscribed, if you haven't downloaded the app, that is in regards to the Unacademy Learners app, please go ahead with downloading it, and then you can also be part of the Unacademy special classes. You can also be part of the Unacademy classes. Next discussion would be tomorrow again 11 o'clock, Pratham. As per the editorials and articles, whichever I feel it will be useful for the prelims and mains point of view, I'll pick up those. Tomorrow again 11 o'clock we will have it. Tomorrow 11 o'clock. Editorials and articles I'll pick up. Or whichever is important. Whichever is important I'll pick up. And then please go ahead with, if you haven't, please go ahead with subscribing using my code SBT10. And thank you all. And then see you tomorrow at 11 o'clock. Thank you all.